And welcome to the Beyond the Dollar Signs podcast with your host, Mark Taylan. Mark, how are you?
Hi, Bill. It's great to see you.
No, it is great to see you. Interesting episode today. All the episodes are interesting, but this one is a particular interest to me because full confession from your producer, Mark, I have to set up an appointment with an estate lawyer. So I'll be paying attention to this one.
Oh, good. Yeah, I'm happy to finally be discussing this. We have a special guest. I'd like to introduce Barbara Pretlove. She's an estate planning attorney and somebody that I've worked with for a few years now. So Barbara, again, I'm happy to welcome you to the show. It's good. I'm glad you're here.
Thank you, Mark. I'm so glad to be here and talking to you about this. Thanks for having me.
Oh, you're very welcome. So let's talk a little bit about you. Estate planning. What got you into the business, and what made you choose this direction as a career?
I actually took the long way around to get to estate planning. I did my undergrad in film and television, and when I graduated with that degree, I moved to Los Angeles and became a producer for music videos. During that course, it was feast and famine, and I ended up doing a lot of the legal side of the production company, staring at contracts, waivers, liabilities, all of that really fun stuff, and decided I wanted a more steady path that I would go back to law school to be an entertainment lawyer. By my second year in law school, when I actually got to take entertainment law class, I realized I made a very big mistake. It was glorified contract law, and I absolutely hated it. It was miserable. I ended up dropping the class and deciding to try a couple of different areas. I took a probate law class, absolutely loved it. Did my third year in law school as an externship at a probate law firm, estate planning law firm.
Okay.
And fell in love with it. I really liked the immediate interaction with families, knowing I could help them. It wasn't this litigation heavy, always fighting in a negative space. It was more positive. I was able to relieve people from stress, give them peace of mind, and play a big role in their passing their legacy and their wealth down to their children.
Yeah, I think that's great. When as a financial advisor, one of the things I think my clients look to me for is peace of mind, right? And knowing, especially, of course, in the earlier you get it, the better, I think. But especially in the later stages of their lives, I believe that it gives them really a strong sense of peace of mind, because they know that things are in order in the event that something happens. And nobody knows when something's going to happen. And I think that's important to, of course, plan for that. One of the things that we talk about, and one of the things I'm glad you're on the show today, is understanding what a living trust is, right? Because I think there's a misconception of what's a living trust, and why is that different than a will? And can you share with us kind of your explanation of what a living trust is?
Sure. It's one of the biggest questions I get asked in my office. I have clients setting up appointments to do a living will, and by the time they leave my office, they realize, oh, we need a trust. To explain the difference between the two, it really is the amount of assets you have. In California, our housing value is so high that almost everyone in California really needs a trust. The threshold right now is about $200,000, and that goes by the fair market value of your house, not your equity, and all your other assets combined. If you have over that amount, you have to have a trust in California. Otherwise, you will be required to go to probate court, whether you have a will or not. Probate court is a nightmare. It takes a very long time to get through. You're lucky if you get through in a year. It's public record, so anyone can kind of come in and listen to your business. And it's very expensive. It's a percentage of your estate that goes to attorneys and the executor. So for a modest, $1 million home that is pretty much anywhere in California, you're looking at least $50,000 in fees.
Wow.
Straight off the bat, just by going to probate. So the solution is to transfer everything to a trust. It's a private document. It's a legal tool where we title your home in the trust, we move your assets to the trust, you lose no control over your assets. You're fully still in control of your assets. And it's just a way to title them that protects you from having to go to that probate court and keeps everything private.
I see. That's I'm glad you're talking about that, because I try to convey that to clients and say, look, I'm not going to give you legal advice, but this is what I've seen. And you talk about that probate process. When your financial affairs are out there in the open, that really means that everybody can view your business, and potentially could somebody say, they owe me money, and could they potentially put a claim on your estate?
Yes, that does happen either way. When you're in probate, it is much more public. When you do a trust, you have automatically, by law, creditors have 1 year to make a claim on the estate. If you do a specific notification in the newspaper, we can shrink that down to 4 months, which happens in probate as well. It's 4 months. But unfortunately, we do have to follow certain creditor laws and make an announcement so they can make their claims.
I see. In regards to the trust, we talk about, you create that document, but it's also important, what I've seen, and most recently, in that a family created a trust, but they didn't fund their assets in the name of the trust. Can you talk a little bit about that? Like, what you create this document, it's geared towards your wishes and what you want to happen, but there's more steps to it. Is that correct?
It is correct. And this unfortunately does happen quite a few times. Not in my office, of course. You will leave my office with a fully funded trust. We transfer your real property into the trust as part of the process. But what does sometimes happen is that house is sold, a new property is purchased, and that part is never transferred back into the trust. There is a court process to go through, that we submit a claim to the court that says this person intended these assets to be transferred into the trust. We have the proof, because there's certain documentation you have to sign that says, I intend all my assets to be held in the trust. We get a court order from the judge that even after you passed away, we can transfer all your property into the trust to make sure we stay out of probate.
I see. Wow. In addition to the house, right? Clients need to put certain assets like investment accounts and bank accounts. I've seen this a number of times. Is there, in regards to the bank accounts, do you normally put every bank account in, or is there a certain dollar threshold versus, and would you maybe add a child or a successor on the account versus putting in the trust? Can you talk a little bit about that?
Sure. Again, very common question. That threshold number in California is about 200,000. I think the exact is 204,000 this year. If you're underneath that amount, and this would be in the aggregate, you get what's called a pour over will. And the pour over will says, my trust is my beneficiary. We can move everything over to the trust after you've died, as long as it's under that $200,000 threshold. If it's over that in the aggregate, that's when the court has to come in, and we need court orders. I always tell my clients, keep your day-to-day checking, because no one's keeping over $200,000 in their day-to-day checking, right? It's a revolving account. It goes up, it goes down. But any large bank accounts, savings, if you're, car collector and you have high value cars, or art collector, anything like that, we want to make sure those items are titled in the trust. When it comes to life insurance or any accounts with a direct pay beneficiary, if there's no reason to lock those assets up in a trust, the preference is for you to name your beneficiaries outright. It completely avoids the trust administration, the probate process, and pays directly to the beneficiary. The reasons you would want to name your trust as a beneficiary of your life insurance, 401ks, IRAs, would be if it's going to minor children. They cannot inherit outright. So I did have a client. He listed his 4-year-old daughter on his life insurance, unfortunately passed away. We had to go get a guardianship put in place for the finances through court for her to get that money. She does not get it outright till she's 18. But in the meantime, her mom has to manage it, report to the court every year. It just causes a lot of headaches and administrative issues. If he had a trust and named the trust as a beneficiary, it would filter into the trust. the trustee would still manage all the funds until that child was of age, but you don't have this huge oversight and court costs and guardianship headache that would come otherwise. So it would be minor children or special needs children, anything like that. I would recommend the trust. Otherwise, send it right outright to your beneficiaries.
Yeah, that makes a lot of sense. I didn't think about the guardianship part of that, right? And the cost involved in the administration. What does that cost? I mean, in general,
a guardianship is going to cost you a few $1,000s to set up, $3 to $5 depending on the attorney, just to set up. And then you can either place the funds in a blocked account, which means anytime you want to pull them out, you have to petition the court, but that saves you from accounting every year. The alternative is an unblocked account where you can utilize as needed. You don't need court approval, but you have to submit an accounting every year. And every time you go to court, whether it's an accounting or to request funds, it's more attorney's fees, more court fees. So the fees really never end until the child becomes of age and can take the money out right on their own.
And even in that case, right, the child when they become of age is 18. Is that correct? And at that point,
correct.
Yeah,
and often it might not be an age you want your child to get, hundreds of thousands of dollars, and make the really smart decisions 18-year-olds make.
Yeah, what I often see from attorneys and families that have done that is it's kind of a graduated schedule, right? Meaning that maybe initially, if they're 18, they don't receive a portion until they're 25 or 30 or 35. And then on top of that, I believe there's some provisions that whoever's managing those assets on their behalf can make the call if they needed medical money for a medical situation or what have you. They have some kind of discretion within the trust, right? Does that make sense? Is that usually the case?
Absolutely. Yes. Yeah. So it's fully customizable. It depends on the family situation. Some people know, my son is already in their 30s and I want this in a trust for life. If he gets a hold of it himself, it's going to be gone. Some people say, no, I know my kids at 25, they can have everything outright. So it's fully customizable to what the client wants. It can be at 25, they get everything outright. At 25, they get 50%. At 30, they get the other 50%. Whatever age they feel is best for their child. And then while the trustee is managing the funds, they can use those funds for the child's health, education, maintenance, and support. Health and education are very standard terms. Maintenance and support give the trustee discretion. So he can say, great, you're getting straight A's, you're turning 16. I can use these trust funds to help you buy a car. Or you're getting married at 23. You don't get everything outright, but I can use these funds for your wedding or your honeymoon, those types of things where the trustee really steps into that parental role and decides what is for the benefit. I can use these funds for whatever works best for their maintenance and support.
Makes sense. I think of a trust as certainly it has some bullet plate kind of template legal speak, as I would call it. But really, I think of it as a document, and please correct me if I'm wrong, as a client can express their wishes from a legal standpoint, right? So you can get very detailed in regards to gifts and what you want to happen. Is that somewhat correct?
Absolutely. Yes, You can. All your personal property. I have clients ranging from let the kids figure it out to very thorough lists that this person is to receive this painting, this person is to receive this car, and they can list everything out that has sentimental value to go to any individual. You can direct real property to certain people. You can do lifetime, what's it called? Drawing a blank on it right now.
Yeah, like lifetime income, like an income stream.
It's for the real property. So they have the right to occupy a real property until their death. Oh, yeah. So this comes into place with blended families, right? Mom and dad have the property. One parent passes away. The kids want their share. In that, the husband has said, no, my wife gets the right to occupy this property until her death. And then at her death, it can be divided between the kids. It's a way to protect the other spouse. And again, this is usually with blended families. So the kids don't come in and try to kick anyone out and say, well, we want our share now.
Yeah, I can see where this is going. We're going to have an episode 2. But let's talk a little bit about, I have a few more questions. We have a little bit of time. The trust there's a difference between a revocable and irrevocable trust. And I think as we talk about the misconceptions and the common myths about trust, one of the things that I see very commonly with a couple that's alive, right, is a revocable trust. And my interpretation is meaning that whatever's written in place now can be changed. And can you talk a little bit about that?
Yes. So the typical trust we do is a revocable living trust. This allows the settlers, who are the creators of the trust, to continually change and update the trust as they see fit. And this even happens when the first spouse passes away. The surviving spouse can update the trust as they see fit. Again, there's caveats there with blended families on a portion becoming irrevocable. The purpose of amending, I have some clients come in every couple years. If big life changes happen, divorces, more grandchildren, they want grandchildren to receive specific gifts. Trustees pass away, they're successor trustees, and they need to update that. It's continually changeable. There are no limitations to what you can update in your trust as long as it's revocable. An irrevocable trust, on the other hand, is once that's created and your assets are transferred in there, short of a court order, which would require everyone consenting, not very easy to do, is completely unchangeable. It is in stone, and what is written in there is what stays. There are very few reasons to do an irrevocable trust at this time.
I see.
So barring one of those reasons, most people are in a regular revocable living trust.
I see. And as you said, life changes, right? And people get older. And what I've seen as a trend is, when I first had my trust, my children were so young. But I was thinking, it's my parents, right? My parents, obviously, that's who would be the person if something happened to me. And then it became my siblings, right? Because my parents are getting older. And now my children are of age. So now it's them, right? And so I see that as a very common transition, in that process. So
it is, yes. So when kids are young, a sibling, sometimes even a professional fiduciary can take on that role. And then when the kids come of age, it does move over to them.
Yeah, that's important. I know, and you also mentioned the fiduciary, right? Sometimes it's not family. Sometimes families choose to have a professional institution like a bank manage their affairs. Yes.
Yeah. And a lot of that is usually clients that have been trustees themselves for their parents'
I see.
property and maybe have had some problematic siblings, and they see that could already be a possibility within their own family. They would go ahead and hire a professional fiduciary, someone that, third party, doesn't have to deal with any of that emotional strain. Because being a trustee can cause a lot of problems within family relationships. I've seen a lot of things go sideways where siblings stop talking to each other. Yeah. So sometimes it is best to just outsource the third party.
Can you share, maybe even as we wrap up, a real life story of something in that regard, right?
Of a contentious family?
Yeah, of a situation. Yeah, of a situation where, maybe they didn't have a trust or they did have a trust and there was contention. I mean, again, family and money is a very delicate subject. I see it all the time. And that's why I really, impress upon my clients to make sure things are in order, make sure things are clear so that your wishes are honored. So,
absolutely. The funniest one is probably one of my very first trust cases that I took on. It was an administration. And in it, the decedent had left 100 head of cattle to his ranch hand, and stated that his ranch hand was able to pick whichever 100 head he wanted. Well, at the time, there was no definition for head of cattle regarding weaned and unweaned calves. So this ranch hand went and picked 100 cows that had unweaned calves. So essentially getting 200. Well, the daughter, I believe it was a daughter, came and obviously went to court to fight over what the intention was, what one head means. So I had to write documentation and research and say, when they're counting head of cattle through the state and when they're being transported, anything like that, they do not count an unweaned calf as a separate head. It is considered one head of cattle. So not only did I end up winning for my client that he got the 100 head of cattle plus the unweaned calves, but it also set a precedent for what head of cattle means in regard to unweaned calves.
Oh
so God. The idea was that the intention of the decedent was that he wanted his ranch hand to have all that.
I see.
But that was an instance where being very clear on what you want to distribute becomes very important. I've also had one, which was not so funny. It was very contentious with regards to a daughter and an uncle fighting over the accounting and whether something was money went missing. There was an account that was supposed to be there. The uncle had done a very casual job of tracking the money, which you cannot do. You have to trace every dime, every penny.
Wow.
And so went on for, almost 3 years fighting in court before they actually were able to just settle, because it was just such a mess. And now they don't talk. They've moved away from each other, and it completely destroyed the family relationship.
I hate hearing stories like that, but that's the reality, right? If things aren't spelled out right, my gosh.
Mm-hmm.
Oh. Well, again, I want to thank you so much for being on the show today. I feel like we could do another podcast and talk another round.
Absolutely, I know.
Would love to see you again.
It's a very information heavy area.
Yeah, absolutely. No, it's been such a pleasure to share your knowledge and experience with you today.
Oh, thank you. It's been a great time.
Yeah, that was actually good listening to it. And Barbara, you get props from me because for a lawyer, you speak rather plainly.
Oh, thank you very much.
It was easy to follow. And I certainly take your point about being specific and being clear. Because it's true. I think that a lot of people think when they create a will, what they're trying to do is forego any contention, so that everybody knows, like, hey,
that is the goal.
I'm curious, though. I was listening and I'm thinking, do you encourage, like, let's say my wife and I came in to sit down with you and go over an estate plan? Would you, or do you encourage those couples to include their children, or a way to at least make sure that the children are informed, so that it's not like a bad made-for-TV movie when everybody sits down and they suddenly are surprised by what's in the will and in the trust?
That is a case-by-case basis.
Okay.
I have both where it is recommended, there's no bad blood, there's no issue, that it's best to explain to your children why you're doing something, right? When more money is going to one child over the other. Mm-hmm. I do always recommend open communication and stating this is why it's happening. And I do have family members or parents that bring their children in so they can ask the questions. Mm-hmm. On the flip side, there is the individuals that say they're going to be so mad that we did this, but we're going to be gone, so it's not our problem. So there is both.
Wow.
I care not what savagery's left behind, because I won't be here. Oh, wow. That's amazing. That is amazing. Well, Mark, thank you for having Barbara on. If people are listening to this podcast and have got more questions, what's the best way for them to reach out? And maybe even, Barbara, we can include you in this as well, for people to get in touch with either one of you. Barbara, why don't you go first, and then we'll finish with Mark.
My law firm is Pretlove Law, so you can find me at pretlovelaw.com, or my office number is 408-850-6402. Call there, make an appointment. If they want to make a consultation, they mention this podcast, I would waive the consultation fee. We can sit down and have a discussion about their specific needs.
Fantastic. And Mark, what's the best way for people to reach out to you and ask questions and get in touch with you? Yeah,
thank you. Both of our contacts will be in the show notes today at the bottom of the episode when it's released. So we'll have that, and people can, schedule online with me and engage, and we can do Zoom meetings. Barbara, I know we're both in Northern California, But do you practice throughout the state of California?
Yes, the entire state of California. I do remote meetings, phone, Zoom, and I do remote planning from anywhere, really, in California.
Very good. Thank you.
Excellent. Excellent. And if you're listening to this podcast and you're not already a subscriber, the first thing you should do is hit the follow button. Because by being a subscriber, you're automatically notified whenever there's a new episode of Mark's podcast. You can listen to it and you won't ever miss another one. The one thing I would ask, by the way, is if you like this podcast, could you please recommend it to people? Word of mouth promotion is invaluable, and we would very much appreciate you taking the time to tell people they think they might benefit from, that you may think they might benefit from listening to it. So until next time, I'm Bill Tucker. On behalf of Mark and everybody at 360 Advisors, thank you for taking the time to listen today, and we'll catch you next time. Thank you for listening to Beyond the Dollar Signs Financial Clarity. Click the follow button to be notified when new episodes become available. Visit our website at advisors360pwm.com or give us a call at 408-778-8280. The information covered and posted represents the views and opinions of the guest and does not necessarily represent the views or opinions of Advisors 360. The content has been made available for informational and educational purposes only. The content is not intended to be a substitute for professional investing advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions that you may have regarding your investment planning. ECA does not provide tax or legal advice. Guest opinions are their own. It may not reflect those of ECA. The viewer is encouraged to seek their own individualized tax and legal advice from a qualified professional.